Hello. Welcome to Bearpaw Media and Education's Public Legal Education webinar series. My name is Nadine Callahoo Hansen. Bearpaw Media and Education is a department of Native Counseling Services of Alberta, and our primary goals are to make public legal education understandable, accessible, and affordable for Indigenous people. We at Bearpaw are not lawyers, although we do endeavor to make sure that this information is correct and current to the best of our abilities, and is edited by lawyers. Of course, laws change with elections and societal values, so this information is designed to be general in nature and may not apply to your specific situation. It may still be necessary to consult a lawyer for legal advice to assist you. For more information, you can go to our website at bearpawlegalresources.ca or follow us on social media at Bearpaw Legal. I'd like to begin by acknowledging that the land in which we gather is Treaty 6 territory and the traditional meeting ground and home for Indigenous people, including the Cree, Saulteaux, Blackfoot, Métis, and Nakota Sioux. Today's topic will be about breach charges. And so I'd like to begin by viewing a video that Bearpaw Media created called Fighting Chance.
I can give you my name, but the gang sign says it all. I'm a part of the tribal warrior gang. Oh, and just because I'm 13, that don't mean I don't know what life is really like. Everyone is out to get you. I take what I want to survive before someone tries to take something from me. That's how it is. That's the truth of where I'm from. It was total bull. I was arrested and charged with theft from a vehicle. But because of my long rap sheet, they were thinking of locking me up in the Young Offenders Center. I thought I was a goner for sure. But then the cop who busted me walked in and told the judge some sappy story about how I was a good kid at heart, but I was at risk. He said he had seen that I was getting close with the gang, but to still give me a chance. He told the judge that I'd be a good candidate for extrajudicial sanctions, whatever that means. And if I followed through with the conditions, they wouldn't lock me up. Sweet deal, right? Man, was I wrong. Once I was arrested, the government put me in a group home. Hell, my own family didn't take me in. They decided they had more important things to do than actually give a crap about me. After a few months, that same cop showed up with some guy named Alex from this native organization called Puna. Alex told me that Puna meant fire for the Cree and that the program had something to do with youth learning responsibility and their role in the family and community. The cop said the attendance of the Puna program was part of my extrajudicial sanction, and if I decided to do the program, Puna would find people who cared about me and get them involved in my life. Alex called it a circle of support. I called it a really bad Hallmark moment. The only support I wanted was from my brother Pete, but he was sitting in a jail cell. Oh, and these Puna meetings? More like phony meetings. I faked my way through them so the cop and judge would sign off. Then one day Alex tossed me some boxing gloves. Good thing too, because I was in the mood for a fight.
Worthless! No wonder your dad left, or you're gonna cry just like your mother.
It's like I couldn't stop. My blood was on fire. I barely even remember what happened next. All I remember was Alex saying something about healing. Later in the program, we started doing this thing called Topway. I sat in a circle with 8 other gang kids who got busted and an old Indian cowboy.
There's a lot of pain and anger in this room, and it comes out through violence and rage. We need to find out where this pain comes from.
What did he want me to say? Hey, my mom's a crack addict and my dad's a deadbeat, my brother's in jail, and I was left to rot? Not the best way to say hi. One day in the program, the old Indian cowboy told us to draw our identity. That was easy. I knew mine was a tribal warrior. After my brother went to jail, they took care of me. But they haven't been around at all since I've been in here. Hell, they really are like my family. They disappeared the second I needed them. I don't need any of them. A couple weeks later in the Top Boy program, I had to draw my family tree, and it was pathetic. Looking down at my crummy piece of paper, I can see how effed my life was. You see on the left there? You can call her my mom. I like to call her a junkie. That's my brother Pete, who's in jail for murdering my stepdad. And my grandparents? I wouldn't know. Never even met him. The Indian cowboy looked at me and said,
Almost everyone in my generation went to residential school, and we all got messed up. This is how all the violence, the addictions, neglect, and abuse was passed on from one generation to the next. All this negativity passes down from your great-grandparents, to your grandparents, to your mother, then it was passed on to you. It's a cycle, but once you know this, you don't always have to wonder why no one cared. We can all break this cycle.
Everything moved so fast. I had no idea how I ended up in a sweat lodge. I never even bought a dream catcher, so why was I even in here?
Adults in your life have failed you. This can't define you for the rest of your life. The reason you are here is because your parents haven't been there for you. For whatever reasons, you need to forgive, to move on, to be healthy. In our Cree culture, a man is to protect our women and children. The children are at the center of the community, and the women put a circle around the children. And the elders form a circle around the women, and the men are the warriors. They are the last circle protecting the whole family. And one day, you will be the final circle, the warriors who protect and provide for your family. It is up to you to make changes in your life. Treat your elders, treat each other with respect, and treat yourself with respect.
Top Boy means the truth, and I spent 3 months looking for mine. I realized I couldn't find family in a gang, and there's no point in being angry with my parents. That was getting me nowhere. And I tried my best to leave that all behind. That cop and Alex said I was a good kid and that I had successfully completed the Puna program and my extrajudicial sanctions. They recommended that the judge drop my charge. The judge agreed. It was the first time I had someone fighting for me. The truth was, whether I liked it or not, I had a choice. I could follow my brother's path or create my own. I had always looked up to my brother, and I know he doesn't want me in here. I would never want to let him down either. I know how bad that hurts. That prison glass made things way clearer for the both of us. I got something he didn't get, a fighting chance. All it took was one person who saw I was worth something, then a whole community who chose to circle me, support me, and protect me.
You can view that video anytime on our website, www.bearpawlegalresources.ca, as well as all of our videos and resources. The number one reason, most common reason why Indigenous youth between the ages of 15 and about 25, mid to late 20s, are serving time sitting in jail isn't because they've committed new offenses. It's because they have committed some type of breach charge. Now, the most common breach charges are failing to appear for court or fingerprints, failing to appear for something. Breach of probation, being unlawfully at large, failing to comply with release conditions, obstruction of justice. And so this would be, for example, if the police pulled somebody over and asked them what their name was, and the police or the person lied and gave a false name, which led the police on a wild goose chase. So this would result in a charge of obstruction of justice. Along those same lines, public mischief. And this public mischief would be, for example, if I had called the police and made a false report against my neighbor, and again, caused the police to go on a wild goose chase. And so then the police would likely find out that the allegations, the accusation was false, and then they would come back to me and they could charge me with public mischief. Perjury is lying while under oath. And so if someone is giving a statement on an affidavit or giving testimony in a trial on the witness stand, they will be asked to swear to tell the truth, the whole truth, and nothing but the truth, so help you God. You can also attest, and many courthouses are now also allowing people the opportunity to attest on a feather or some other culturally relevant item. Interestingly, the maximum sentence for perjury, lying while under oath, is 14 years in jail. So people might not think that it's such a big deal, but if you've ever seen, or excuse me, if you've ever heard the saying, you're only as good as your word. Ultimately, that's what this means, is that if you are lying, you are proving to the courts that you can't be trusted, you can't be believed. And people take that very seriously. And so the consequences or the potential sentences for perjury, as well as ultimately breach charges, can be extremely serious. Also, allowing or assisting someone to escape lawful custody. If somebody knows that a friend or a family member that the police are searching for them, and they allow them into their home and they help to hide them, they can also be charged with aiding and abetting, assisting somebody to escape the police. And so that's also classified as a criminal offense and can be extremely serious in sentencing. So when people are charged with some type of criminal offense, they once they've been charged, they'll either be released on their own recognizance, or if they're not, they will be granted, it is their absolute charter rights to have a bail hearing, because only a judge has the ultimate power to deny somebody their freedom. The police don't have that power. the Crown Prosecutor, nobody. The police and the Crown Prosecutor can recommend that bail be denied, but ultimately only a judge or a justice of the peace has that kind of power. Once somebody has been granted release, whether it is on their own recognizance or on their own promise to appear or whatever, then they will also be given release conditions. And it is important that people abide or follow those release conditions while they are waiting for their court appearances. So standard conditions would be keep the peace, be of good behavior, and appear before the courts when required to do so. They might have a condition that they must report in person to a bail supervisor or a probation officer, or even to the police on a regular basis leading up to the completion of their court process. Notify the court of any change of address, phone number, etc. Standard. Remain in the province. Again, standard. This is on all release conditions, or release documents, whether it's a promise to appear or a recognizance or even a probation order, which is also a form of release. Then there will be extras, may or may not be extras. But what people need to realize about the additional conditions is that they will always be in direct correlation to what the alleged charge is. So for example, if somebody was charged with committing an offense after dark, they may have a curfew. Keep in mind that these conditions are designed to help people stay out of trouble. And so be in the house before dark, perfect. If an alleged offense, because remember, we're all innocent until proven guilty, right? So alleged, you've been accused of something, but they haven't proven whether you are innocent or guilty yet. So they have to always assume that you're innocent until proven guilty. All right. So the alleged offense may have occurred while somebody was under the influence of alcohol or drugs. And so they're likely going to have a release condition that they must abstain from all alcohol and non-prescription drugs. Makes sense. Maintain full-time employment or education. Sure, busy people have less of an opportunity to get in trouble. People may even be required to attend for assessment, counseling, or treatment, for sure. Other common, very common conditions, besides abstaining from alcohol and drugs, there may be a no contact list. So if the alleged offenses occurred while someone was in the company of someone else, they're likely going to have a no contact order. Or if there are alleged victims, then there may be a no contact order there as well. Or if a person has a lengthy record that involves other people that are common to the courts, well known to the courts, then the judge may put a no contact order, just a blanket general no contact that can be amended from time to time by the probation officer. So the no contact can be as general or as specific as the court's order. Also, another fairly common one is not to be in possession of a cell phone or a paging device. This is common, very common with drug charges, drug trafficking. What's the best way to prevent somebody from continuing to traffic drugs? Take their form of communication away. If you can't get a hold of them, or if they can't get a hold of you, they can't make the sale. And so the one thing I just want you to remember about these conditions is that they're really designed to help people to stay out of trouble. And they will always be in direct relation to the alleged crime. So some common release documents. Now, these are the papers that people will have to sign in order to be released. So an appearance notice, a promise to appear, an undertaking, or a recognizance, and a probation order is also a common release document. These are all designed to have conditions to help people to stay out of trouble, and hopefully they will successfully complete to the end of their term, and then it's all done. So why is it really important to follow your release conditions? First of all, if somebody breaches, remember I had said earlier that we're only as good as our word, right? And so when somebody is arrested and charged with something, and then the police are deciding, or the judge is deciding, whether a person should be allowed to be released and continue living as usual during their court process, or if bail should be denied. They're going to consider how good your word is. How well do you keep your promise, right? And so every time somebody breaches a release condition, it tells the criminal justice personnel that bail should be denied because that person can't be trusted or believed. They've broken their promises. It also indicates to the criminal justice personnel that any future conditions that are placed by the courts on that person aren't going to be followed anyway. So why bother? Because they're not going to follow them anyway. And also, it appears that the courts and the judges view breach charges as most serious, requiring a short, sharp shock or jail sentence. And so people might get away with a breach charge with, not a slap on the wrist or whatever, the first two or, a couple of times. But at some point, the courts and the judge are going to say, you know what, we need to do something serious to get this person to pay attention and take what's happening seriously. And yes, they do put people in jail for breach charges. So when people go through bail hearings, there are some terms that they will commonly hear. So the two most common things that they will hear are primary and secondary grounds. And so my brother-in-law, who's a judge and used to teach law, once told me that where bail hearings are concerned, it is far more important to know what not to say than what to say. Because what a person might present, the kind of information about themselves that a person would present in a sentencing hearing is completely opposite to what somebody wants to present in a bail hearing. So it's important to know what the Crown prosecutor and the judge are looking for when they are considering bail. And so primary grounds. The only thing that the courts are looking at is, if we release this person, are they going to show up for court? So the kinds of things they're going to look at is a person's record. If they have lots of failing to appears previously, they're not likely going to be granted bail on primary grounds because they've proven that they can't be trusted to show up for court. So are there any prior failing to appear charges? They're going to look at the person's connection to the area. Do they live in the area? Do they work in the area? Typically, the Crown prosecution has a rule of thumb that if somebody lives more than 100 kilometers away from the court location, they will usually ask for cash bail. Do they have a job? So what kind of supports and connection does a person have in that area. And that all plays a big part in primary grounds and primary considerations for bail release. And so, just go back to that for a second. And so, if somebody is going through a bail hearing, they're going to want to make sure that they're going to let the Crown prosecutor and the judge know that they have family in the area, they're working or going to school, that there are far more reasons why they would choose to stay in the area and deal with their court charges than to flee, than to run. All right, so that's the kind of information that a person would want to present in defense of themselves through a bail hearing on primary grounds. And then we have secondary grounds. And with secondary grounds, what the courts are looking at are indications that if we release this person, are they going to continue committing crimes? And so the kinds of things that they're going to be looking at is prior breach charges. What's the person's living conditions? Is there a drug and alcohol addiction issue? What length is their criminal record? And how recent are those convictions? And so typically, if somebody thinks that they're going to throw themselves on the mercy of the court and say, I got kicked out of my home, I don't have a place to live, I'm, couch surfing, whatever. Ultimately, what somebody is doing is proving to the courts that bail should be denied based on secondary grounds. And so you want to be very careful about the kind of information that you're presenting in a bail hearing, particularly in making sure you're not proving that bail should be denied on secondary grounds. So here is where you want to make sure that the courts understand that you have lots of support in the community. If you are connected to any programs, now's a good time to make that indication. If there were prior breach charges on their record, then they want to present information that proves to the courts that their situation is different and more secure now than it was before. Maybe that person, the accused, wasn't connected to a court program, or didn't have a lawyer previously, or recognizes that they have an addiction problem and are making arrangements to get into treatment. All of these things will add to a supportive defense in a bail hearing. So that's secondary grounds. So primary grounds, are they a flight risk? Are they going to show up for court or not? Secondary grounds, if we release them, are they going to continue committing crimes? And so at that point, they're looking at everything in a person's life. And then we have a third condition in bail called tertiary grounds, which most people will never hear about. It's so rarely used, but it is a catch-all. So this would be used if, say, somebody qualified for bail on primary and secondary grounds, but the crime is gang or hate affiliated, connected to gangs or particularly violent crimes. And it would be an absolute offense to the community because of the violence of the crime and the strength of the case itself. And so sometimes in rare cases, the Crown may recommend that bail is denied based on tertiary grounds, but you're probably not likely to hear that very often. Alberta now has something called Bill 9, which is the Enforcement of Minor Offences Act. And the reason why it's important to know about Bill 9 is because the province and the courts now have very different ways of dealing with fines. And so it is Any type of fine, whether it is municipal, so the town or city you live in, or Alberta or even federal fines, have the right to impose a fine as a punishment for an offense. Each level of government has different ways to make sure that the fines are paid. With municipal fines, they're imposed when you violated a city bylaw, such as a parking ticket or jaywalking or riding on the public transportation without a ticket. And those fines are paid to the City of Edmonton, and any court appearances will still happen in provincial court. Then we have provincial fines, which are imposed when someone has violated a provincial law, such as speeding, public intoxication, or hunting and wildlife violations. Traffic violations are dealt with in traffic courts, and others are dealt with in provincial court by the Crown Prosecutor. Federal fines are imposed when somebody has violated a federal law, such as impaired driving, theft, assault, or any other criminal charge that can result in a fine. In addition, many other federal statutes can also impose fines for environmental statutes, etc. And these fines are dealt with in the criminal division of provincial court. So what's considered a minor offense? All provincial and municipal bylaw offenses, both traffic and non-traffic, with a specified penalty of $1,000 or less, not including the surcharge, committed on or after May 1st, 2017, so pretty much everyone now, must be charged using a Part 3, a yellow offense notice, unless the peace officer thinks that it's in the best public interest to issue a Part 2 pink summons. This can be without a voluntary payment option. So you want, if you did receive a pink ticket, check the voluntary payment option box near the top. If it's been checked off, then you have the right to just pay the ticket. If it hasn't been checked off, then you have to appear in court. Court appearance is mandatory. So what are your payment options? Go to the courthouse on or before your court date. And of course, with COVID, they're now asking people to pay their fines online. However, if you don't agree with the fine, you can ask the judge or the traffic commissioner if they would consider reducing the fine. They will sometimes consider the fine amount, your ability to pay, and the nature of the offense, and do have the ability to adjust the fine accordingly. You can also ask for more time to pay. So if you're able to pay, but you need a longer time, you can ask the courts for time to pay, and they will extend that without penalty. They can also give you a payment plan, particularly with really large fines. So for example, if someone's been charged and found guilty of driving without valid insurance, the first offense on no insurance is $2,875, including the victim surcharge. Well, I don't know about you, but I couldn't just dig deep in my pockets and pull out almost $3,000 and say, there, take it. And so you could ask for time to pay. And usually with very large fines, the courts will set you up on a payment plan. And as long as you say pay $250 every 3 months, that time will continue to be extended. So you do have deadlines throughout. Or if the fine has default time. So sometimes if, let's say for impaired, if someone was fined $2,000 for impaired driving, in default, 10 days, let's just say in default 10 days. What that means is it's the court's way of saying that if they don't pay the fine, they would have to serve 10 days in jail. So then their deadline date for the payment, the fine payment comes up. They haven't paid, it'll go to warrant. They'll be arrested and it becomes a pay or stay. You either pay the fine or you serve your 10 days. So if there is default time in default, you can ask to be referred to the fine option program. If you can't pay the fine, you can work it off. And so your file would be referred to usually the probation office, not always, but usually, and they will set you up in some type of nonprofit organization or another charitable organization that could benefit from your volunteer work, sort of. And you would be credited, your fine would be credited for the hours that you've worked, and you can work that off as well. So there are several options on how to make that payment. The program is available for those who don't have an income and are facing the risk of jail time. So in default, that default time for non-payment. You must be at least 18 and able to work in Canada. It's an alternative measures program, so you must plead guilty and it must be your first or second offense. You'll be assigned to work in community service projects, hours between 8 a.m. and midnight any day of the week. You will earn credits for hours you worked at minimum wage, so $15 per hour. It may be in lieu of a supplementary, maybe in lieu of or supplementary to another form of payment. So if you can pay some of your fine, but you can also work off a portion. So it doesn't have to be all or none. It can be a combination of. When you have enough credits, a voucher is issued to the clerk of the court indicating that the fine has been paid in full. And if you don't complete the program, you'd have to pay the outstanding debt, be given a fine, or may have to go to serve your time in jail. So what if you don't pay? Legal fines never go away unless you take action. In Alberta, the court sends overdue fines to registries, and that's the important piece to Bill 9, is that all fines up to $1,000 are no longer issued warrants. The courts can still issue warrants for fines, but typically they would rather have their police forces going after, hardcore criminals than spending a lot of their time chasing after people who have warrants for their arrest because they failed to pay fines, right? Definitely a better use of a police officer's time than that. So fines up to $1,000 are usually, more often than not, referred to registries. So when that happens, you'll not be able to get any services at registries until you pay your fines in full. So you go to renew your driver's license or your registration or anything to do with registries, and you're going to find out that you're not going to have access until you pay your fines. That happened to me a couple of times, and you do not want to go renew your annual registration and find out you've got $1,500 worth of outstanding speeding tickets. You got to love those photo radars, right? And speeding tickets are huge. Like even one, you're looking at over $100 usually, if not more. So it doesn't take long to add up. And you won't even be able to sell your car until your fines are paid. So you can't even sell your car to pay the fines. So there you go. If you don't use Department of Motor Vehicle Services, your property may be seized, or your wages, bank account, or tax returns may also be garnished. And so there are certainly, it's most convenient to attach it to the Department of Motor Vehicles, but they also have other alternatives available as well. If your ticket goes to registries, for Part 3 fines, the court adds late payment fees of $20 or 20% of the tickets, whichever are greater. And registries will also charge a user fee to pay and an extra fee if you pay with a credit card. I always, when I have a speeding ticket, which I try not to get anymore, but when I do, I prefer to pay at the courthouse because I don't have to pay the registry fee. I still have to pay the late fee, but I don't have to pay the registry agent fee. How long are your services? How long until your services are restored? If you pay at the registry, your services are restored immediately. If you pay at the courthouse, you usually have to wait a day or so before the registry agent, the system at the registry agent shows that the payment has been received. Or if your income tax was garnished, you may have to wait up to 2 months before services at registries are restored. So if you have questions or concerns about your fine, you can contact the Fines Enforcement Program in Alberta or Edmonton, 780-415-2969, or you can go through Service Alberta toll free 310-0000. The fax number 780-415-6026. Not all overdue fines are linked to motor vehicle registration. You would have to contact the Fines Enforcement Program to determine which fine or ticket you have outstanding. Consequences of not dealing with fines. Driving without valid license. So if you have fines and they've been sent to registries, and you just don't deal with them and you don't renew your driver's license, registration, etc. The fine for driving without a valid license, up to $500 fine or 6 months in jail. If someone is caught driving without a valid registration, $270 fine. Driving without valid insurance, and this is the first offense, anywhere from $2,500 to $10,000 plus 6 months to 45 days prison plus 15% victim surcharge. So it could be just a $2,500 fine plus a $275 victim surcharge, but it could extend up to $10,000 or up to 45 days in jail. So some very serious consequences to not dealing with fines and getting caught without valid license, registration, insurance. Driving without valid license plates, $270 fine as well. Also, criminal records. And so breach charges, those kinds of things. Another reason why somebody would want to follow their release conditions and follow the direction of the courts is you don't want a criminal record. If you can get referral to an extrajudicial measures or sanctions program, that's best, absolutely best, because at the end of that process, charges are withdrawn and there is no criminal records. There's this big myth that when people turn 18, their criminal records disappear. That's not the case. That's not true at all. The way that youth records are, how they work is that once a youth has completed their last sentence, so let's say somebody is 17 and they get 12 months probation, they would have to complete the 12 months probation successfully, and then depending on whether the charge was summary or indictable, summary being the less serious, indictable would be a very serious charge. So if it's a summary offense, they would have to wait 3 years from the completion of their sentence before their youth record would disappear. If it's an indictable offense, it's 5 years. So that person could be 19, 21, anywhere from 21 to 23 before their youth record disappears as well. If that youth commits a new offense anywhere but during that 3 to 5 year wait time, their youth record will permanently attach to their adult record and will never disappear unless they apply for something called a record suspension. We no longer have pardons in Canada, we have record suspensions, which is a fairly lengthy and costly process. And so, best course of action, don't break the law if you can help it. Don't breach if you can help it, because that will result in further charges and longer records. Criminal records will limit people's educational and employment opportunities and extremely restricts travel outside of the country. And so if you are thinking you might want to go to Disneyland or Disney World at some point after COVID, you definitely don't want a criminal record. If you're thinking about going into some type of career opportunity where you're likely going to be asked to provide a criminal record check, you're definitely not going to want to have a criminal record at that point as well. And just keep in mind that youth records do not automatically disappear when people turn 18. There's a useful online resource to help people to move beyond convictions, and I've provided the link here. It's Ex-Offenders Workbook as well. And so certainly anybody that did wind up getting a criminal record and is looking to move beyond that, they can certainly go to these two resources to get help on moving past that criminal record. And so this concludes the breach charge workshop. Thanks for attending. Thanks for watching.